How to respond to a trademark descriptiveness refusal. Have you received a trademark descriptiveness refusal and are unsure how to respond? This situation can be tricky, but understanding the process can help you navigate it effectively. A descriptiveness refusal happens when the United States Patent and Trademark Office determines that your trademark merely describes a characteristic or quality of your goods or services. This means your mark is not inherently distinctive enough for registration on the principal register without additional proof. To start, it is essential to understand the basis of the refusal. The refusal is grounded in Section 2, subsection E, Clause 1 of the Trademark Act. This section prevents the registration of marks that convey information about the goods or services rather than identifying their source. For instance, if you use the word creamy for yogurt, it describes a product quality and is deemed merely descriptive. Next, evaluate your mark's distinctiveness. Ask yourself if your mark is truly descriptive or if it has unique elements that set it apart from merely descriptive terms. This evaluation is vital in deciding your response strategy. Once you have assessed your mark, you can present arguments and evidence to counter the refusal. You may submit a response to the examining attorney arguing that your mark is not merely descriptive. This can include evidence that your mark is suggestive rather than descriptive. Suggestive marks requiring some imagination to connect them to the goods or services. Additionally, you can provide evidence of acquired distinctiveness, also known as secondary meaning. This shows that consumers associate your mark specifically with your goods or services due to extensive use and promotion. You may also present evidence that your mark has a different meaning in the relevant market or context that is not descriptive. If your mark is indeed descriptive but not distinctive enough for the principal register, consider amending your application to the Supplemental Register. This register offers some protection but does not provide all the benefits of the principal register. Be prepared for the possibility of an appeal. If the examining attorney maintains the refusal after your response, you may receive a final office action. At this point, you can file an appeal with the Trademark Trial and Appeal Board if you have strong legal arguments or new evidence. Alternatively, you may consider abandoning the application or rebranding if the refusal cannot be overcome. Practical considerations include working with a trademark attorney who has experience in responding to office actions. They can help craft persuasive arguments and gather supporting evidence. Collect consumer surveys, advertising materials, sales data, or media recognition that demonstrate acquired distinctiveness. Avoid relying solely on generic or dictionary definitions, as the United States Patent and Trademark Office focuses on the mark's significance in the marketplace. Responding to a trademark descriptiveness refusal involves analyzing your mark, submitting persuasive legal arguments and evidence to show distinctiveness or acquired distinctiveness, considering alternative registration options, and potentially appealing if necessary. This process requires careful attention to the United States Patent and Trademark Office rules and precedents to maximize your chances of successful registration.